Hello, 101.5 FM.
Election hearing so far were prefatory comments.
Well, Ken, I'm saying
this was transit street na my I just okasa na mbeye.
I'm saying so far election petition officially no assembly na shase. And I think say enroll was day one in terms of the hearing Nankasa. Before say be hearing as no na other stages are na judicial process no happen, including the filing of applications and Supreme Court SOA determination and all those things. It is expected, say, as the judges said, hearing is starting on Monday. Court number 12, so the hearing will progress smoothly without any difficulties. Now, and some air course or court, your court in some air course. And it so appears to say there's also the politics of it, which is playing out in the public. I will focus so much on what is happening in court and not what is happening in the public. As far as public sentiments are concerned, I don't count. See, one of those political things they say, Nipa person will create a certain impression. Say petition na NDC for the Supreme Court no. Yempesi be diasem. And for that matter, and near the application about. The applications are the banning now. No, the basic aim is to delay the trial of the matter. We are very sure say one more person something now. If you try lawyers, they know deep down within their heart say yes, I'm assembly. There is a petition in NDC for a file challenging the constitutionality of the declaration.
NDC na file and answer John Mahama.
President Mahama. But of course, when I say the NDC, I'm just stretching the argument. Say it is on the ticket of the NDC. Not President Mahama contested election. So I wouldn't be wrong to say NDC. So forgive me when I mention the NDC instead of the president. This petition that President Mahama filed now, people should understand. Say he is seeking to challenge the declaration of the election results. On the 9th of December 2020. Now the law allows to say once our file petition and as our file substantive suit you are allowed to file applications. Applications there are the they got to court the court. Me the master maba about down one say infini di. Asem ne guso yedi. Ba yen di wie no me say oye adistredi we mami and as oye we mami. That is all it is about. So me very sure say the lawyers themselves know say so far no NDC enye bibia untoward. So far NDC enye bibia you better say one percent in a deliberate manner. One person delay petition no. Of course, the petition no koye. Say if they say you copy justice from the Supreme Court and you in the first place. That's what I'm saying. Say the no, there is the legal aspect of it which plays out in court. Every lawyer said the no is very, 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 very normal. But then outside the courtroom though, then the usual politicking. I say painty will be black and I say painty will be negative, no, and so And now something interesting happened in the Supreme Court. Obesha, Jones they say don't ketia ejina dakem. Edi adanse from witness statement no. Court meji ni witness statement to me. And my electoral commission lawyer, shall say a cross examination. Cross examination or year. Then it came to the turn of the second respondent's counsel, and also share the cross examination. I say, but in new baby, in the course of cross examination, which means one question, the cross examination.
Now we need the over beside. It could be say, we are now he even meant to ask 2-3 questions.
It is possible, but I'm just trying to draw your attention to something. May count this one in the light of the perception in someone can some of them so deliberate say almost create a certain picture in America. I share cross-examination. I say the Supreme Court gave him the opportunity to cross-examine. After a couple of questions, no, so follow or the pen drive. Be by us, our pen drive, no, a can. NPP4 case when you're part of the NDC's case. In fact, a NPP4 witness statement no more file, you know. And on this our pen drive, no, a can as one more exhibit. Besides, you don't get here about the pen drive, the content of the pen drive. Okay, say no pen drive, no, on one change, that is what stalled the whole process. I call for adjournment because then the Supreme Court judges no bizarre. I could say now if you have such a thing, when say electronic evidence, anything as you should have brought an application earlier on so that arrangement would have been made. Nanka Supreme Court you now opese yen na yehwe say audio say video opese yen na yehwe na say tie na asam no traso no nka no registry would have made that arrangement nanka ya boni tie na fe you move on. Or your lawyers have strategies. He chose to say over we do court away and stand on his feet no after direction if we court no. But the point is here I'm citing this one as an example to tell you, say, but for, Sadia na is see, you know, in cross examination, you know, so don't forget, say, yes, before you soon know your own cross examination every year. But for the issue of, if I say electronic evidence, if I see a boy and I say, yes, you know, idea, you know, we continue. So, can anybody now draw a conclusion, say, boy, fire? And the second respondent, now, and that is so delay case, nah. And I want my who near that proud.
Now we are lawyer ni say wo person wo di dance bi and ade bi e dance di eba court ese say wo di kai e court na sutra na say obetimi aspring ade na at any point in time during the trial.
No, spring that then you're surprised. But on this particular occasion, you're surprised because document now no person will cross examine on already no on my filing. It is part of the case of the second respondent. But that's what I said. You're surprised. It's already before the court.
All right.
I have several the other side at the other side near them.
You bet me assume say so far other side no money.
It's a document that has been served on the other side. That has been served on the petitioner. So the petitioner no it will be that. But the point is that so your cross examination now. Don't forget say no you see don't get here in the dinner document. Respondents na cross examine isi edunketia. So they say. So you don't expect isi edunketia to know their case because that's what they say. Because it is their case. So many opportunities for someone all those exhibits, the court will give them the opportunity to play it out. But to try to put idea your case to the opponent who is who is giving evidence in chief. So no. And a process near a story. Point is that on the part of the NDC, say it was a deliberate attempt. Say second respondent personal on person and no assembly 12. Because don't forget that very thing in the Supreme Court, it tried as some class about Monday, so that perhaps Monday may sure say arrangement would have been made for the audio or the video to be played out. So say for us as lawyers, we know say BB across course will be it's a normal thing, it's part of the judicial process. Obia canasem. Until the outside the courtroom, the picture now for person painting saying obia smart court and on here prepared no here read no does not arise at all.
Me person ade bi say no. Say first respondent no. Lawyer no ebusa say don't get your question. I will say on your petitioner. Na our honor as what? Na say don't get your court or Sunday.
Don't forget say don't get your by court for. So they say as a witness. If I just what I say. Now, we be question now. You must be some question or what knowledge of personally. Me share was no see our dear mammy ya. Who say witness statement yeah, say don't get your file. Along the line, no, NPPs raise the objection to some of them. So some of the paragraphs no go and your matters I can't NDC for some until you can say court no matter paragraphs no age now witness statement. Supreme Court in its ruling no deleted some of the paragraphs. And one of the reasons why some of the paragraphs were deleted is say matters is here any personal knowledge of. It is here in your synopsis. And that Sankaya petitioner they would have allowed those paragraphs to stand. So it is not out of place.
Menya sure say nyina or say enye ade or personal knowledge of. For instance, baby or claim say the relationship between First Lady and menya sure say almost striking out because of lack of personal knowledge, but I felt say almost feels like it was irrelevant to that.
Very good. So the point I want to make is that from your own synopsis, at least 2 of the paragraphs, Supreme Court is striking out. The reason the Supreme Court is striking out, they say, is here don't get here any personal knowledge of those matters. And in fact, it concluded by saying that if the petitioner himself was testifying, then they would have allowed for that. And you know, it is not.
At this point, a big say, Casey, whom say petitioner nankasano, or no, or mama kasa, but a bit me about point bia, wemo council, no bit me say. Ye pia be fini ho petitioner na ho tie subpoena no and say ye check court na ma court no amor is that possible?
No, I don't foresee that thing happening.
No, is that possible? Me busa me can say BC. Me busa because of say ye why we na we lawyer.
No, that one cannot happen. Okay. The reason being that see we subpoena. The law is clear say me na me masama court. Me na me choose witnesses me do mbeba court am mbeka masama me. But that's what I say. When I conduct 2 case, in the end, you choose witnesses the friend of material witnesses. If you say I'm put your case across to the court. The court will only subpoena a person. For instance, a perform a duty of a public nature. So, for instance, you're a medical doctor or for instance, postmortem on somebody, or you're a surveyor, or you land be so near there. And when you rendered that duty in your capacity as a public officer. In CPBB, if you that's a Maya, the court can even call you as an expert witness. Say, court. Oh, Maya, that one the court will subpoena you. But the court will not go into the arena of main and main case. If I feel that this witness is material, now the never mini case. If I feel so I am material, it is my case. So the court will not, if the court does that, they mean say, court of Hamba could be an idea.
Edura after court proceedings no me say NPP lawyers no ba ko kase jo mama na kasa o de nasem no necessary ko ba e ba be kanasem ena me say NDC lawyers no me kai we the Dr. Yeni oba no no so questions e before no mo kasa no almost be kai say 2013 na nado wa ma metena ho na no so de akinye bi aba say 2013 nipa obetena ho kasa no na oye petitioner. He was part of the petition here and I'm so no me 3 na Jake President Akufo-Addo, then candidate Akufo-Addo and Dr. Bawumia. And you know 2 scenarios not can be same. Say obi kasa 2013 Akufo-Addo ama mi gina ho no kasa no. At least one of the petitioners came to testify. Yes, Anamukano. Yes, sir.
Yes.
Okay.
Yeah,
and no, some person me person be busa because now quite years and 2013 Bawumia na baba kasa na nya na do. But what I recall was Bawumia himself was a petitioner now.
No petitioner na do na Bawumia me I don't
no them. No me 3 me kai. Jake na party chairman the candidate and the vice.
Candidate
But aside, what I'm telling you as a matter of fact in law, and I say, me, I'm the case upon. I choose the witnesses I'm not a member. Under no circumstance, the court never compel me say, offer witness, offer witness, and your court never come as mama. If the court does that, it means that the court is going into the arena of helping a particular party to tell a story.
This time you are not talking as NDC. Oh, Kasa say lawyer near our church and to Miss Rochelle. Say, me, I'm a fan, say me, what's me? Be a measure abem Ediama Kenneth. One Kasa Uniho. But be a messumis to say, be a wo, no, I send be a busao. I be court to me, my home crimes are.
On this occasion, are you referring to President Nanado? President
Mahama. President Mahama is accusing the first respondent, the EC, of more or less fixing the election for the second respondent. And I mean, say, bet me, I possible say, first respondent now, there easy or there are some asem. Or bet me, I say, wow, there are some we are some person Busa was busy. Maybe Busa, I'm just trying to.
Because it will not happen. Because don't forget, the petitioner have filed a petition, no? So they say in the personal capacity, not in his capacity as a public officer. In fact, that's what I say. And you know, on no decide witnesses or one member. On no file a petition.
I'm sure there are some automation. I also represent Busa Wangaza.
No, you cannot do that. Okay. That's what I'm saying. That.
Point well noted. Let me present. There be now a problem. There be
it shouldn't be a problem at all.
Okay.
So, and you know, to wind up, no, who say applications are also, and one of them is the review application. How they might say, there's an application petitioner can file it. So these are certain questions from the first respondent electoral commission. Nanka questions are very, very simple questions. You either admit or deny. The respondents don't mount to a very strong opposition to that. Emma, sa application in the Supreme Court by unanimous decision dismiss it. Petitioners not file a review application to that. Now, Sisi Aminoka says, "I review application and so you dismiss it." Almost dismiss it, review application, on ground say these are questions that the petitioner, if he so desires, with maybe sir, in cross-examination, the respondent no witness ever. Now, to those who are saying, say, Obi, I deliberate of a set of mass a delay. No. The question is, questions are very simple. I will answer yes, no, yes, no, yes, no. It will be fast. Ama, you move forward. And at the same questions, no, I have to use cross-examination about 2 or 3 days and send them about in terms of expedition. When a person in your expeditious trial, this is what I say. With what is happening now, there's for us as lawyers, the course will call through the SCSA. Then those who want to play politics of it outside the courtroom, so they are entitled to do so. But it is very important, say, the NDC's case, as it is before the Supreme Court, no, it's a very solid case. The BIS petitioner no ensure say only the justice are open, the lawyers or more. And at the end of the day, no, we all expect say there will be justice in this matter.
Thank you.
Hello, 101.5 FM.